must be almost a Kafkaesque nightmare to be in a situation where you're not able to access your child because of another state's legal system. So contracting states should be required to be transparent in all of their actions. But there is a real risk, as other members have stated, that the Convention is being used by some to protect the abducting parents' actions. If parents are to have confidence in the fairness of the Convention, I believe it is time to consider whether the Convention is effectively meeting its aims and purpose. From the stories we've heard this afternoon, I do not believe that is happening. The case of my constituent is a tragedy, and it is time that it is brought to an end. Thank you.
I call Jonathan Lord.
Thank you, Madam Chair, for the opportunity to speak in this debate. And like my colleagues, I believe this is a very important topic, and I commend my honourable friend, the member for Ruislip Northwood and Pinner, for securing this debate. First, I would like to welcome the supporters of the group Hague Mothers who are attending this debate. As we all know, the 1980 Hague Convention was intended to ensure the quick and safe return of children removed from their primary carers and taken abroad by their non-custodial parents. In that regard, the Convention is highly effective. However, Hague Mothers point out that around 75% of the parents who are brought before the courts are mothers with primary care of their children, most of whom are fleeing domestic abuse or trying to protect their children from abuse. And there are limited options under the Convention for mothers to oppose orders for the return of their children, and in most cases the courts decide that the child must return. The only defence available under the Convention that could apply to domestic abuse is the Article 13b defence, which provides that the court may not order return of a child if the person opposing return establishes that, and I quote, there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation, end quote. The courts of most contracting states interpret what constitutes a grave risk very strictly. Most cases of domestic abuse are not considered to give rise to a grave risk or intolerable situation for a child. In particular, it's almost impossible for mothers to prove that coercive and controlling behaviour, which since 2015 quite rightly is a criminal offence in England and Wales, constitutes the basis for an Article 13b defence. And despite the Domestic Abuse Act 2021 stipulating that children who see or experience the effects of domestic abuse are victims in their own right, those same children can and are returned to the country and often the care of the abusive parent. Mothers escaping domestic abuse across borders are therefore left in the terrible position of having to choose whether to return with their children or send their children back on their own. Most mothers decide to return and face continued or worse post-separation abuse, and sometimes destitution or homelessness or isolation or even criminal proceedings. They frequently have little or no family, social, financial or legal support, which of course then provides a perfect context for continued abuse. Second, I would like to bring to the attention of the House and the Foreign Office to the case of my constituent Natalie Anderson, who is appealing for assistance from the UK government in bringing her twin boys safely to the UK from Croatia.
May I just ask the member and remind him this is, I take it, not a live case in UK courts that he's referring to?
It is not a live case in the UK courts.
Thank you.
Natalie Anderson's British-Croatian twin boys, now 9 years old, were, she says, taken back to Croatia on the pretext of a holiday by their father in 2016, just as the family had been establishing their life, including schooling for their children, in England. She requests that the British government escalates her complaint about Croatia with the bodies of the European Union. She warns that parental alienation claims can be used to cover up child abuse, including child abduction, to award custody to abducting or abusive parents, and to stop mothers and children moving to locations where they would have more favourable living conditions. She believes that this is what has happened to her and her children in Croatia. She believes further that mothers and children who are not protected properly from domestic abuse have a human and legal right to asylum in another country, and that these rights should be upheld and enforced. She asks that the phenomenon of mothers and children fleeing across borders to escape from abuse be considered a humanitarian crisis. And she advocates for the approach advanced by the Hague Mothers Project as one which could be easily implemented and would do much to support the safety and welfare of mothers and children in this situation. In her own words, Natalie Anderson says, and I quote, "This is now a child welfare matter. These are vulnerable children, and it's unconscionable that the Croatian authorities have been violating their rights, wishes and welfare needs for so long. I am appealing for the urgent assistance of the UK government in bringing my children safely home." And she also requests that the British government raises the question of her case with all the relevant bodies of the European Union. I have been trying to help and assist my constituent Natalie Anderson. I'm grateful to the Foreign Office and the Passport Office for correspondence that I've received back from them, and I know how assiduous our Foreign Office officials and our embassy officials and consular officials can and often are and often can be. But I would appeal to the Foreign Office ministers to have one further look at this case. I won't take any more time of this House today, but I think it is an important debate, and I've been very interested to hear the other individual cases that other honourable members have brought forward today.
We're now starting on the front bench speeches, so I'll call Anam Croissar for the SNP.
Thank you, Madam Chair. It's a pleasure to serve again under your chairwomanship. I'd start by congratulating the Honourable Member for Ruslip, Northwood and Pinner for securing this incredibly important debate. He started his contribution which was incredibly reasoned, and he set out a very measured tone for this debate, which appears to have, in fact, cross-party support. He, of course, referred to his constituent and the disappointing engagement from the Polish authorities, and my thoughts are with the family and the child, and I do sincerely hope that they're reunited. Madam Chair, I've been taken aback and moved by the stories raised by honourable members from across the House about the cases that their constituents have faced, and of course the public gallery is pretty full as well. So we really must do whatever we can to ensure that we're preventing these horrific crimes. And whilst I don't have children, I can only imagine that child abduction is every parent's worst nightmare. A nightmare worsened, of course, when there's an international dimension. As the members for, and I apologise if I don't pronounce your constituencies correctly, but Bolsover, Hendon and Woking highlighted the horror of an abduction is only